negotiation proposals conducted pursuant to sections 179A.01 to 179A.25, which if you go to that particular statute, it talks about negotiation procedures. Initiation of negotiation. First of all, what we are talking about with these advisory panels is that they're not negotiating anything. They are developing questions to ask the candidates. They're not negotiating. They're not negotiating salary. They're not negotiating anything to do with it. Plus, the initiation of negotiation under 179A.14 is this, under subsection 1, that first agreement, when an exclusive representative desires to meet and negotiate an initial agreement establishing terms and conditions of employment. That's what that falls under. Secondly, the public policy of this particular statute of 179A.01 is that it's to govern the relationships between public employees and employer governing bodies for the need for cooperation and employment protection. These questions that the panels are developing has nothing to do with employment protection. And then under 13D.05, where it talks about meetings having data classified as not public, when a meeting must be closed, data that would identify alleged victims, active investigative data, educational data, health data, and individuals' medical records, a public body shall close one or more of the meetings for consideration of allegations or charges against an individual. Then it also talks about meetings that may be closed to determine the asking price for real or personal property, to review confidential or non-public appraisal data, to develop or consider offers or counteroffers for the purchase or sale of real property or personal property. And then finally, when you go to the definitions under Chapter 13 of general non-public data, if you look at labor relations information, and this is the definition for that, it means management positions on economic or non-economic items that have not been presented during the collective bargaining process or interest arbitration. And so while I know that this council wants to say that these meetings can be closed while the bodies are, the advisory bodies are putting together their questions on what they will ask the potential candidates, these questions are based upon the recruitment profile, and based upon that recruitment profile, which is not secret to anybody, because that's why the people have submitted their resume, is based on that, I do not believe that we have any legal authority to close these meetings and not have them be subject to the open meeting law, and that where this statute is to be construed in favor of public access, and few exceptions that exist are to be carefully restrained to avoid abuse. And that is a quote from a Minnesota Supreme Court case. So that's my position.
Funny, but we have later on the agenda, which we're not going to put off until the 15th, City Attorney contracts, and I don't believe I saw your name.
And I can put out my position, Ms. Juneman, and I will, and you can just disagree.
Which you did. I move that we close the meetings.
Second.
Okay, we have a motion and second before us for closing the advisory meetings.
Madam Mayor, I think we should hear from the city attorney.
Madam Mayor, members of the council, the resolution as written simply authorizes the closing at such a time as the chair deems it appropriate. I'm not suggesting that the entirety of those meetings be closed, just when the subject comes up, for what that's worth. Slight nuance, but it does put the authority in the chair there. So,
all right. That would seem to be logical. It seems like what's normally happens. You open a meeting, you close part.
Move the resolution then?
I'm just saying that, you know, at some point during the meeting,
unclear,
it might come up.
The meetings be closed.
Oh, I see. Sorry.
Like I said, a very subtle nuance, but
Resolution.
the resolution. It's late.
Second again.